So on that note, I will hand over to Andy, who's going to speak to us today about serious injury claims and making a difference.
Thanks for going easy on that. Right, that's the title of my talk. What we will cover, not blood, not guts, not gore. But essentially, I feel a bit like I'm the warm-up act for what's to follow. We've got some great talks lined up really to follow on from what Theo was reflecting on. Very, very interesting. So over the next 50 minutes or so, and I'm a bit of a wanderer, I'm sorry, I do wander when I'm talking, how we as serious injury lawyers can help with this pathway from roadside to rehab. And we'll explore as we go through the various facets of that. I'm not going to read all this, that's the plan for today. So back to basics. Why do we bother with any of this? Why should anybody bother making a serious injury claim or any compensation claim for injury for that matter? Well, this quote probably puts it better than I can. So the aim is to put the injured person back in the position they would have been in had none of this happened, so had the trauma not happened, insofar as money can achieve that. There are a number of cornerstones to this, but these four feel pretty important. So early financial support, so it's getting early benefit support and advice, interim payments early on where we can, because we all know that when someone is seriously injured and can't work, the bills keep on coming. So anything we can do to alleviate one of their worries has got to be a good thing. So that is absolutely paramount. Instructing a specialist case manager, well, there are loads of you in the room. It's just so important that we get the right people involved early, getting an immediate needs assessment done early, working out what we can do to help our seriously injured clients to improve their quality of life, because we all know that getting involved early is absolutely key. Working in collaboration is vital, and I would say that extends to everyone you come across in this arena. So whether it's the clients and their families, whether it's you as the case managers, allied health professionals, part of the MDT, experts, defendants. I've found over the years, my default is always to try to get on with my opponent at the insurance company or the solicitors later down the line, because I found that if we're all pulling in the same direction, it makes it a darn sight easier. You do get times that doesn't happen and you just get on with it, but it does make it much, much easier if everybody is sensible about things. We're not going to agree on everything with defendants, but if we can be sensible and have grown-up conversations, makes it so much easier. And then evidence. I'm not going to talk about evidence anymore for now, because I go to town on it a bit later. Okay, so that's the theory. How does it all work in practice? So I've talked about the early involvement. That's really essential. So there are times when I will be asked to go out and see a client, whether in hospital or at home or in a rehab facility, quite early on in the piece. And as I say, that's tremendously helpful, because it feels to me that we can make a difference really early on. We can make a good plan with you as the case managers as to the direction of travel. It doesn't always happen. Sometimes we are not the first lawyers involved. Sometimes my record is probably being involved about 11 years down the line on a child brain injury case. One lawyer had been dealing with the case for 11 years. The family got fed up and came to us, and that was a first for me. And it was before the days of paperless or paperlight, and I can't remember how many lorries turned up with the boxes of files, but slightly daunting moment. And that was in the days of offices. So my office was basically sort of like a shrine to this case. Generally, when we go out and see clients, we'll have a bit of a snippet about what happened, but probably not that much information. So enough to be thinking about what the key issues are going to be and the areas that we maybe need to look at and focus on. But not enough to be forming fixed preconceptions about the direction of travel. And that's a good thing in my view, because part of that initial meeting is actually about talking with the client, talking with their family, and understanding what the priorities are and the pressure points are from their perspective, because they may be worrying about completely different things to the things I think they'll be worrying about, if that makes sense. So going in with an open mind is probably a better way of putting it, and then ultimately working with them to make a good plan in terms of what we're going to try to achieve, roughly when we can achieve it, and also managing expectations in the sense that, you know, it's all too easy to go in and promise the earth, but we need to build up trust with the people that we're working with. We're not going to achieve that if we promise the earth and deliver nothing. So we need to be realistic, we need to be sensible, and tell them very clearly what we can help with, and as I say, the timescales. I've talked about interim payments and benefits, and I can't emphasise enough how vital they are in the process. So come the end of the meeting, that first meeting with the client and their family, we want to come up in as far as we can with a clear and agreed plan of action, sort of touching on all the things I've just mentioned, but broken down really into two bits: the legal pathway and the rehab pathway. And anyone who's heard me talk before will say, is he banging on about this again? But really, the legal pathway is just the legal case. So making sure that clients understand what the process involves. So how long is it going to take to establish liability, for example, or fault on the part of the person we're proceeding against? When are they going to be seeing experts? And how long is it all going to take? I remember sitting down with a family on a case I'd taken over from a colleague, and this case was several years down the line. And I said to the family, look, you know this case is probably going to take another 15 or so years. It was a very young child who'd suffered a serious brain injury very early on in life. And mum and dad sat there, and once the sort of initial shock had subsided and they'd picked their jaw back up off the table, they said, you know what, thanks ever so much for telling me that, because no one's ever mentioned that before, and at least we now know that we're in for the very long haul. And I explained it on the basis that, look, we need to get to a position where the medical experts in the case and other experts can give us a really clear prognosis as to how all of this is impacting your child, and we can then properly assess the value of the claim. Sorry, that's quite long-winded on the legal pathway. And then the rehab pathway is making sure that clients understand what's involved. So, okay, you're going to send me off to meet with a case manager. How's that going to help me? You know, I need money to pay my bills. I don't need any rehab. It's about understanding how you as case managers and allied health professionals can help. And then it's about involving the right people. Again, explaining what's realistic, what's achievable, and you know what making a plan, as I say. Okay, so when I'm meeting with a new client, I'll be thinking about what type of case manager is right for them. So in many ways, the experience and the expertise is a bit of a given. I'm looking at more subtle stuff like personality type, interests they might have, you know, even styles of communication. So I'm thinking, who is the client going to get on with? But ultimately, it's a really personal decision, isn't it, choosing a case manager? So I can select one or two people who I think will be really suitable, but ultimately I want the client and potentially their family to be making that decision, because you know as well as I do that the client case manager relationship can be a very intense one. And in many cases, it can far outlive the litigation. So you're involved for years after we've finished our involvement. So, and unfortunately, there are cases I've become involved in where we're, you know, 3 or 4 case managers down the line, which is, it's just so destabilising for the family and for the client that I mean, sometimes it's unavoidable, but it's a really important point in the case, bringing a case manager and an MDT on board. And I'm really fortunate. I work with some brilliant case managers, many of whom are in the room today, and it's great to see you again. Okay, so we've thought about what we're going to do in terms of the rehab. So what do we actually do? Well, we need to make contact with our opponent as soon as we can. And that will generally, in the first instance, be an insurance company. And we want to tell them what's happened, because generally they won't really engage with us if they don't have a feel for what's happened. Generally, they will need something in writing, whether it's a letter of claim or a letter of notification under the Serious Injury Guide. And I'll be wanting an early conversation with them about rehab. And it's really frustrating when you get complete radio silence from insurers. If it was a member of their family, they would blooming well engage with this. But because it's not, and because they're bean counting or they can't be bothered or whatever it might be, they don't always engage. But I don't let them get away with it. I keep going till we get to where we need to. And even if it's a question of going off and getting an INA unilaterally to show them what's needed, then we'll do it. And sometimes, and I was chatting through with some people about this last night and this morning, and I don't like looking at things in this way, but as I see it, sometimes it's about talking the insurer's language. So a bit of money spent now on rehab means a smaller cheque at the end. And I think that, that can be useful at times. But you've just got to have the courage of your convictions with this sort of stuff. Don't give up. It's so vital. Here's an interesting one. Unilateral or joint instruction? Seems to divide opinion. So I always ask case managers when I go out and talk to them, what do you prefer? Do you have a view? And it's mixed. I think it's fair to say. I think my take on it would be that it depends on the case. So if we have a very clear-cut case on liability, it's probably one where we would very seriously consider a unilateral instruction, which generally would be funded by the insurers through interim payments. Equally, there are cases where you go with a joint instruction, or you might start with a joint instruction and then progress to a unilateral later down the line. Or you might have a bit of a blend of the two, as Beth and I were discussing yesterday evening. A reason for going with joint instruction can be if you've got difficulties on liability, or there are likely to be significant deductions for contributory negligence, whereby the claimant was partly to blame. Or sometimes, it's the only way forward and the insurers won't agree otherwise. So it might be a case where you just take what you can get in the early stages. But there may come a point in the case where you think, as I say, you may transfer from a joint to a unilateral. And one of those instances could be where it becomes a joint instruction in name only, where effectively the insurers are saying, well, we're not going to carry on funding this, or this under the rehab code, but we'll do it as an interim payment on a general basis. And you start to think, well, actually, there's no point. We may as well just take the leap to a unilateral instruction. So it's important to be thinking in the early stages, how is all of this going to be paid for, and keeping that under review. And we'll talk in a moment about forward planning in that regard. I was going to say something really poignant. It's escaped me. That was it. Clear communication is vital. It's sort of a recurrent, well, it's actually there. Great. Clear communication is vital. And sometimes I'll pick up the phone to a case manager and I'll say, look, I've got this case. The defendants are not engaging with me. I think we're going to win, but it's going to take a while to get there. Are you prepared to take a risk with me on this case? Do the INA. You're not going to get paid straight away. But I really feel it's imperative that we get an assessment done. And many case managers I know will do that. And it's great because it enables us to get that initial assessment. And as long as I am communicating regularly with them, hopefully they will remain on board and understand that we're doing the best that we can to push things along with the rehab. the worst thing in the world is having an INA that gathers dust. It's frustrating for everyone, and the reality is that once you get to the point of being able to proceed, there's probably going to need to be a review of the recommendations anyway. Last point, getting very excited about this red dot. Attending MDT meetings, I don't really know what other lawyers do in other firms, but I take them really seriously. So whenever I'm invited, I will go. And obviously during lockdown, we had lots of remote meetings, which reduced the travel time. But I think the reality is that being at the MDTs for us as the lawyers is vital. And I think there are two main reasons, and hopefully I'll remember them both. The first one is, I think it shows a real commitment to the clients and the families and the MDT, that we're actually bothered about the rehab and that we want to engage with it. And it's not just something we're doing to bump up the schedule of loss, which we're absolutely not. We actually care, and we want it to help and improve our clients' quality of life. And I think by us being there, we're taking part in the conversations, we're listening to what's being said, we're contributing to the discussions, and I just think it's invaluable. You can read all the reports you want, and they're absolutely paramount, but actually being there and hearing these discussions going on is, it's second to none for me. And the second reason is, I said I hope I remember them. The second reason is, I think, a follow-on from the first, which is that the source of information that you get from these meetings. I mean, if you didn't attend, yes, you'd get the minutes, yes, you'd get the updates, which would be brilliant, but actually there is no substitute for being there. If I have forgotten the genuine second reason, I will remember and go back to that, but I'm sure that was it. I just got a bit keen and did both points at once. Okay, right. Sharing expert reports with case managers and the MDT. Any thoughts on that before I give my take? Glorious silence. Okay, thank you. I think it's really important, actually. I've put privilege question mark because it's a potential bear trap, in the sense that if a report hasn't been disclosed to the other side and we're sharing it with the case manager and potentially members of the MDT, one has to be tremendously careful that this document does not go into the public domain and form part of the client's records, medical records, education records, whatever. Because the minute that happens, the defendants can see them. And if the report isn't complete, then our case is compromised potentially. So one has to be tremendously careful. And again, Beth and me were discussing our approaches on this last night. And it's probably one of the issues that sort of takes you to a unilateral instruction being more favourable than a joint, where in a joint you're thinking, well, can I send the report to the case manager if it's that arrangement? I think the reality is it's a case-by-case decision. Thinking ahead, excuse me. Thinking ahead is vital, and one of the things I really value in the work that I do is having the bandwidth to actually think about my case. I know that sounds blooming obvious, but it's so important, because if you're not making a plan for a case, keeping that plan under review, because things develop fast, don't they, in our cases? Things happen and we need to be able to react to them. So we need to be making plans for cases. We'll come on in a moment to, thinking about experts, getting on experts' waiting lists, and just putting ourselves in a good position so we've got a direction of travel and it's not just rudderless. Sometimes, and thankfully not too often, there are times when you feel like you're being reactive, not proactive. And when that becomes a recurring theme, it's obvious. But as long as it's the exception rather than the norm, then I can live with that. But in general terms, looking at cases regularly, where am I going with this? Do I need to reappraise my strategy? maybe discussing it with a colleague. It's something we do a lot at Lee Day, and it works really well. Just bouncing ideas around. Yeah, have you had a case where such and such happened? And just sharing ideas. It works brilliantly. But the other reason thinking ahead is vital is to keep money in the coffers for interim payments. So there's no good coming to you as the case manager saying, right, we're going to run out of money next week. We need an update report tomorrow. Because you know as well as I do that it takes a long time to prepare these reports. You're going to have to think about the case, get your head into it, and speak with the MDT, get updates from them, get their costings, and it's a big undertaking. So it's much better to say to the case manager, well, look, in about 2 or 3 months, we're probably going to need some more cash. Can you put together a report in, say, the next month or whatever it might be? I mean, the timescales might vary slightly, but you get the idea. And then everybody can approach it with a calm head in a composed way, and there's less chance of stuff being overlooked because it's not being done in a last-minute panic. Once we've got the report, we obviously want it to be clear and comprehensive in terms of setting out what's needed and why. And actually what I think is quite important as well is to highlight the progress that's been made to date to show it's all working. And also what happens if these recommendations aren't implemented. Because I think insurers in particular need to know that. It's about giving them the right information so they can understand the risks. And we all know that for insurers, information is power. Because in the first instance, it allows them to set their limits. There is a word which escapes me. Somebody will shout it out if they know it. Reserve, that's the one. They'll set their reserve, and then they will keep the reserve under review in the light of new information that comes in. And that's important for them because ultimately they need to know how much it's all going to cost them. Right. No, I didn't want to go back. Thank you. So we'll send that report then to the defendants, the insurers or the solicitors, whoever's dealing for them. And we'll say, right, we need X amount for the following reasons. And I'll probably say to them, irrespective of whether it's a joint or a unilateral instruction, look, if you want to have a chat with me and the case manager about any misgivings that you've got, let's do it. Because, again, it comes back to that collaboration, which is key. And it really frustrates me when insurers will say, oh, I'm not sure we want to do that. Or worse still, loss adjusters or claims handlers will say to me, oh, my insurers have instructed me not to do that. Why wouldn't you have a three-way conversation? It's progressing the matter, it's being collaborative, and it's hopefully working towards a common goal. It doesn't always happen, though. So if the defendants don't give us what we want, then we may have to issue an application at court to get a judge to force them to give us the money that we want. And then we're looking at what extra evidence might we need in support of the application. So we might need some expert commentary, which certainly recent case law suggests the independence of that evidence is a vital consideration in these applications, because the case manager and the MDT, whilst they're doing a fantastic job, are sort of in it day in, day out. So having that sort of one step back view from the expert is vital. But also from you as case managers and members of the MDT, we're going to need witness statements of fact. What's been done? Why was it done? What's being proposed? And why is it being proposed? So it's patently clear to all concerned why the money is needed. So I said I'd come back to evidence. I wondered how many evidences to write, and 3 felt about okay. So that first point there kind of encapsulates for me where we're trying to get to with the evidence. So we want to understand what's happened to the claimant, to our client, and the impact of that, not just now, but forever, for the rest of their life, so that we can get to a point where we can properly quantify the case and try to bring it to a close. Sometimes it can be really helpful to get an initial clinical report This is a brain injury conference, as Beth helpfully reminded us, and there are times when our clients don't have a clue what happened, or they might remember part of what happened. They might not be very reliable historians. So actually getting a clinical report from a consultant in the hospital or the rehab facility where they are or have been can be really useful. I've only done it a handful of times over the years, so it's not for every case. But where it's complex, and probably where we don't yet have the medical records, it can be an invaluable point of reference. I've had case managers say to me over the years, do you know what, that report is really helpful. It's a short, factual report, but it just gives us a nice, almost like a chronology to look at. And it only needs to be 3 or 4 pages. Obviously, it's not an expert report. I said before about the importance of thinking early doors about which experts we're going to be involving in a case. So things change on cases, of course they do, but in the early stages we should have a decent feel for what disciplines need to be involved and which particular experts. And just like the best case managers are busy, the best barristers are busy, the best allied health professionals are busy, so that applies to experts. And they have long waiting lists. I mean, for neuropsychologists and neuropsychiatrists and rehab consultants, the wait can be a year and sometimes more. So to try to mitigate the delays, we want to get on the waiting list as soon as we can, so we're as best we can avoiding these delays. That's not any criticism of experts, they're victims of their own success, but it's just a reality. Excuse me. I'm making a bit of a habit of stating the obvious, but sometimes it's helpful, certainly for me. Clear instructions to experts is absolutely paramount. I've learned over the years that actually an expert report that comes out the other side is only as good as the information that you provide to the expert. So you might think they know everything, but actually if you don't tell them, they're not going to know. So my letters of instruction tend to be really detailed. I'm trying to pick out what are the key issues, both in terms of what I've been told by the client, by family members, by others involved in the client's life, whether it's employers or friends, whoever it might be. So I'm incorporating what I think is the relevant information from those sources. I'm telling the expert who's involved in the MDT. I'm giving them the case manager's telephone number and email and saying contact them, talk to them, because they're going to be a really useful source of information for you. And hopefully it will avoid too many wrinkles later down the line with things like the case manager and the MDT going in one direction with rehab and the expert perhaps taking a different view. So those early discussions can, I think, be really helpful. Another obvious point, we need to tell the experts what are the issues that we want them to talk about in their reports. They might be really experienced and they might know what to talk about, but we should still say it because there will be particular issues for each case that are important. Included in that is things like when do you want to see the client again and do an update report? These are the expert disciplines we're instructing or thinking of instructing. Is there anyone we've missed? Things like that. I'll try not to state the bleeding obvious again, but this bottom one is key. When we're instructing, thank you. Did I sound croaky? When we're instructing experts and counsel, it's absolutely paramount that we're giving you proper bundles that are comprehensive, well set out, and just easy to navigate. It's mainly electronic nowadays, I guess, and I can't take any credit for the beautiful way in which my bundles are set out. It's absolutely nothing to do with me, but I know what a good bundle looks like, and it just makes a huge difference. And the sort of dormant paranoia that keeps me going with that is that an expert isn't going to see a particular document And then he's going to end up in the witness box being cross-examined by the defendant's barrister, who says, well, Dr. So-and-so, have you not seen this particular document? And there's a risk then that the judge will potentially find part or all of that expert's evidence not credible because they haven't considered potentially important information. So I will always err on the side of caution with sending stuff to experts. I've talked about the case manager and the MDT, vital source of information for experts, in my opinion. I'm not saying this is the only way of doing things, but it's kind of the way I've developed it over the years, and I'm always looking for better ways of doing stuff. So if anybody's got any ideas, then they'd be very gratefully received. We've dealt with the second point as well. Sorry, I'm jumping ahead. There we are. Sharing draft reports between experts. So be careful. Be careful because it's key, in my view, for experts to be seeing each other's reports, particularly as the case nears joint statement stage. Because as far as possible, we as the lawyers want to be able to manage the evidence. If there are disagreements or issues as between our experts, we need to know about it. And we need to be able to understand whether it's going to cause us a big problem. So we need to be able to have that open discussion with experts so they understand what each other is saying. I promise this is the last time I'll use this phrase, but the bear trap, obviously, is that a draft report is referred to in a final report. And if that happens, it can cause unnecessary distractions, as you can imagine. Dealing with new issues, it kind of comes back to something, well, partly something we were talking about a few minutes ago, which is being organised and thinking ahead about cases. But there are times where things develop, things change. And experts might come to us and say, well, look, I've taken this issue as far as I can. You need someone either of another discipline or more specialist in a particular niche area. Great, that's fine, we can do that, it's no problem. And sometimes, yeah, we might be up against it, but if we're thinking ahead and planning and doing things in good time and not waiting till the last minute, we give ourselves a really good chance of dealing with it in a calm and composed way. To be able to find the right expert and to be able to explain to a judge, if it gets that far, why this expert's evidence is needed. Joint statements, forgive me for a moment teaching you to suck eggs, but the joint statement stage is a pivotal moment in litigation where experts of like discipline from opposing parties, so the neuro rehab consultant, sorry to pick on you, Ruth, from on one side and the neuro rehab consultant from the other will talk and or exchange email, and they'll talk about the issues they agree on and the issues they disagree on, and then they'll prepare a joint statement setting all of that out. And in the case of areas that aren't agreed, then we need them to say why. Again, my instructions to experts tend to be very detailed for joint statements. Normally we'll have had a conference with experts, so we'll have aired the key issues during that. But I think it's vital that we're setting out the key issues, and it helps me to remind myself in the lead up to trial as to what the relevant background and context is. And more than that, setting out what are the points we want the joint statement to deal with. So it's not necessarily setting a formal agenda, but it's saying to our expert, look, these are the points that we really need you to cover. An example of where joint statements can go spectacularly wrong follows. I did everything I've just said with a particular expert on a particular case a number of years ago, and got the joint statement back and read it. And when I picked my jaw up off the desk, I read back over this expert's previous evidence. And it seemed to me that there wasn't really much correlation between the two. So effectively, the expert had changed their evidence in the joint statement. So I rang them, experienced expert this was, and I said, thank you very much for the joint statement. I did honestly say that. I may have misread, but could you just explain to me why what's in the joint statement doesn't seem to resemble what you've said in your previous evidence, which we discussed not that long ago in conference? And I can't honestly remember the exact wording, but it was along the lines of, well, I'm sorry, I just needed to get it done. Didn't really read the papers properly. And I kid you not, it was definitely not a career highlight having to then explain that to the client, because when it happens with a defendant's expert, it's great, because it really consolidates our case and makes us feel really happy and really confident. But when it happens to you, it's the complete polar opposite. In the end, we got a great result on a difficult case for the client, but that did cause us unnecessary distraction, worry, complication, and all of those horrible things. Sleepless nights as well. Another part of thinking ahead is, goodness me, I don't know my own strength. Which experts need to attend trial, when and for how long? Generally, that's a decision we have to make quite early on in the life of the litigation, probably around the time that we're working with the court and the other side to set our budget for what our costs are going to be. And so we don't really know at that stage for sure which areas, which issues, which expert disciplines are going to be the ones in dispute. So we have to err on the side of caution. And it's a balancing act, and I'm sure the barristers in the room will have a view on this, but mine is, as I say, to err on the side of caution, because what I don't want is experts just to turn up on the day when they're giving oral evidence, because actually they might miss something from a lay witness or another expert. So it's a little bit more intricate. So it's a balancing act between that on the one hand, but on the other, not irritating the judge by having ridiculously high fees for all experts attending trial for 10 days. It's going to be very difficult to justify that. In some cases it might be necessary, but it's a balancing act. So we've got the evidence to a point where we feel we understand properly the impact of what's happened, both now and in the future. Then we're thinking about, well, what does that mean in financial terms? How are we doing for time? Are we okay, Beth? Really? Wow, sorry. Didn't realise I was getting carried away. So we're thinking about these two elements. General damages for pain, suffering and loss of amenity, and special damages, which effectively are the financial consequence of the injuries. So where you hear of cases concluding for millions of pounds, 7 or 8 figures, it's not because of the compensation for general damages, it's because of how that impacts on the client's needs. Things like loss of earnings, care, support, accommodation costs, deputyship costs, and particularly in the case of a young claimant, those losses can go on for years. So, I'm going way back now, sorry. So, special damages can... Are you fiddling, Michael? I'll have a word with you later. One more on, please. Thank you very much. So special damages can include, I was only joking, can include virtually anything, as long as they're justified by evidence. And I've listed some of the bits and bobs there that are the typical heads of loss that we include in a schedule. And my general approach is that I will draft the schedule and then I'll send it to a barrister to tell me the bits I've missed or got wrong. But it's important to have a second pair of eyes look at it, because there may be stuff we've missed or not approached in the best way. So it's important to have two sets of eyes looking at it, absolutely. So the timing of settlement, I'm going to be a bit selective of what I talk about given the time constraints now. Ideally, we settle once we've had a clear prognosis from all the experts, so we know properly what the impact of the injuries is. But we don't always live in an ideal world. So there are times where, for example, we might get a very well-pitched early offer. Insurers seem to have this knack of pitching offers that really make you sit up and think. And generally what I'll say to clients is, look, we've had this early offer in, but the reality is that I can't properly tell you whether it's a good offer because we just don't have the full evidence. It's too early. So generally my advice will be just let it go, don't take it. But there might be reasons why we want to consider the offer. Clients might be desperate to settle for whatever reason, and as long as they have capacity to make that decision, then they can make it as an informed decision, as long as they understand the risks and ramifications that, for example, they might end up being undercompensated if things get worse in the future. But it might also be important to think about early settlement when it's a really, really difficult case on liability. So you end up having a conversation with the client or the litigation friend along the lines of, well, do you want finality and certainty now, or do you want another 3 or 4 years and run a pretty high risk of getting nothing? Very difficult decision to make, and we'd obviously be having conversations with our barrister and risk assessing so that we're giving our clients the absolute best possible advice we can. Thinking about, I'm not going to talk about the means of settlement, it's pretty obvious from the slide. We're looking at whether a lump sum is appropriate, or it might be a combination of a lump sum and a periodical payment if there are life expectancy issues. Again, relevant to this being a brain injury conference, provisional damages might be a risk in terms of post-traumatic epilepsy. So we need to understand what, if any, future risks there are, how likely are they, so that we can make sure we're factoring that in if we need to, so the client can come back to court if this risk comes to pass. And in the case of a client who lacks capacity to litigate, then any compromise of their claim, whether it's in respect of liability or quantum or both, will need court approval. Do you want me to talk about this, or do you want me to move on? Okay. So we've worked hard with everyone involved to get the best possible result we can. We want to do the best we can as well to protect that money, and in particular to make it work as hard as possible so that in as much as it can, it covers everything that's needed for as long as it's needed. Again, it doesn't always happen, particularly if there are deductions for contributory negligence or whatever it might be. And that can lead to some very difficult conversations. But in broad terms, it's important for clients to have good financial advice so they can understand what the projections are in terms of how long the money's going to last, and for peace of mind, if nothing else. And obviously that will need to be reviewed on a regular basis. If capacity is an issue, excuse me again, then we need to identify that early on and get to the bottom of it. So unless, again, I absolutely err on the side of caution with this, if I have any concerns about a client's capacity, I'll speak with them, I'll speak with the family, I'll speak with the case manager and members of the MDT, see what the experts are saying. If we've got that far, we may not have got to the expert stage. So if there are any concerns, I will get capacity assessed, and then if need be, I'll get someone like Amy, where are you? Amy Chater, who's our Court of Protection partner, involved. And I'll do that early for a number of reasons. First, because I want someone like Amy involved early doors so she can get her feet under the table with the case, basically, and get to know the client and the family. But also because it takes a while, or can take a while, to get a deputy on board. I think there was a stage where it was probably taking in the region of a year, but I'm pleased to hear that it's, by the sounds of it, much quicker now. There are cases where clients are capacitous, but it's still important to think about mechanisms for protecting their money. For example, if they or anyone in their household is on means-tested benefits, You set up a personal injury trust and the damages are then ring-fenced. So they're not taken into account, as I'm sure you all know, when benefits eligibility is being assessed. But also, even if they don't get benefits, there might be merit in considering a trust, for example, to protect the money from potentially predatory family members. Say that very carefully. Get it out any quicker. Because suddenly people become very popular when they've got this big damages award. I've talked about investment advice. Thought I'd end on a nice optimistic note. Some common pitfalls. Most of these we've talked about, and in the interest of time I won't labour, but I'll talk about the first two. Surveillance footage, thankfully not something I've seen much over the years, but certainly when it does land on your desk, it's a bit of a heart-stopping moment because you think, goodness me, what's it going to show? And basically it will have been the defendant's, excuse me, the defendant's insurance company commissioning a private investigator to film our clients. So my approach is to be really calm when I get the footage. I look back at the evidence. What's the client saying they can and can't do in their statement, and what are they telling the experts? And keeping that firmly in mind when I watch the footage. Then I watch it. I probably watch it a few times, and I make sure I've got the full and unedited version, because it might be the insurers have just sent us the lowlights. And then I'll talk to the client about it, and I'll try and watch it with them, and we'll form a view as to whether it's benign or whether it causes us any issues. Either way, we'll probably get our experts to watch it and talk about it, just in case we've missed something. There can be reasons why that there are inconsistencies between the pleaded case and what's shown on the footage, and obviously experts can assist us in that regard. But if there are inconsistencies that are blatant, then that probably gets us into the territory of fundamental dishonesty, which again, thankfully isn't something I see very much at all in my day-to-day practice, but it's perhaps worthy of a moment or two of reflection. So fundamental, and I'm by no means an expert on fundamental dishonesty, I should make that very clear, but I just want to sort of flag up a couple of important bits. So fundamental dishonesty is something that goes to the heart of a claim. There's got to be an intention to deceive. It's not just a question of a minor inconsistency between two pieces of evidence. It's got to be something more than that. And if ultimately a claimant is found to have been fundamentally dishonest, then the consequences are about as bad as it gets. The case will get booted out in its entirety, even the truthful and honest bits, the whole thing goes. Probably the claimant will have to pay, so they won't get any compensation. Probably the claimant will have to pay the other side's legal costs out of their own pocket. They might get put in prison for contempt of court, and they might also get sued for the tort of deceit. So pretty drastic consequences. And when you see surveillance footage that is so obviously not in keeping with what your understanding had been as you were going along, there's no feeling like it. It's absolutely horrible. But as I say, thankfully not something we see often. All the rest of these bits are bits we've covered, so I'm not going to labour, but I'm going to take Beth's advice and try and end on a positive, which is this. I've really enjoyed reflecting on the work that we do, and I'm really enjoying listening to the other elements of the pathway. And it sort of highlights to me how important that collaborative approach is. And we really enjoy what we do, and we really enjoy working with people who enjoy working with us. So hopefully that's a positive enough note to end on. And it's slightly embarrassing, but on this next slide, I think I'm wearing the same jumper that I've got on today. So,